Friends, good evening. Welcome to the NKM Chambers LEX PONDER webinar series 2020. Today we have with us a very erudite and a distinguished speaker, Mr.Jern-Fei Ng, Queen's Counsel at the Essex Court Chambers. Mr. Jern-Fei is one among the youngest Queen's Counsel to be designated at the age of 38, and he's a specialist in international arbitration and commercial litigation. And he's appeared almost in every important arbitral tribunal and forums across the world. And he's known for his extremely sharp grasp of the subject, his razor-sharp memory, and his ability to perceive things completely out of the box that makes him the go-to person for all the big corporate entities across the world. I have had the pleasure of listening to him in the Singapore conference recently, where I've witnessed the volley of information and knowledge that he has, and how beautifully he connects it to the subject. Thank you very much, Mr. Jern-Fei. It's a pleasure to have you today amidst your very busy schedule. And the topic that we are going to discuss today is of utmost relevance. International commercial arbitration over the last 2 to 3 decades, especially in Asia, has become the norm. And as we all know, litigation has in fact taken a backseat, and people, in terms of international businesses, prefer having international commercial arbitration as the preferred mode of dispute resolution. So what has changed in these 20 years? What developments have taken place? What are the challenges that have come? We are all awaiting to hear it from the expert himself, Mr. Jern-Fei Ng. Mr. Jern-Fei, without any ado, I leave the floor open to you. Thank you very much. We are all ears for your lecture.
Well, thank you very much, Naveen. A very good evening to you all, ladies and gentlemen. And first and foremost, I'd like to thank Mr.Naveen Kumar Murthi and NKM Law Chambers for inviting me to address you this evening in the LEX PONDER 2020 webinar series. The topic which I've been asked to speak on today is fairly broad in nature, but it is to do with developments in international arbitration in Asia from 2K to 2020. And when I was invited to speak on this topic, I thought long and hard about what I was going to address you all on today and what I considered to be amongst the most important developments in international arbitration in Asia over the past 20 years. And initially, I thought what I would do is I would conduct a survey of all the important international arbitration developments, whether they be cases or legislative developments or other such developments spread over the entire 20-year period. However, it got me thinking that in particular in 2020, the circumstances in which we find ourselves now is obviously fundamentally different from what it was, say, 20 years ago in the year 2000 and in the years that then followed thereafter. And what I wanted to do was, in fact, focus more on some of the more significant developments, both this year as well as in perhaps the previous 2 years. So we're really covering the tail end of the 2000 to 2020 period, because the issues which I am proposing to cover in this evening's webinar really are the ones which, in my view, are more likely than not to affect your practices as lawyers, or if you are not practicing lawyers, then you may well be affected or otherwise come into contact with some of these issues in circumstances if you are an end user of dispute resolution, including but not limited to arbitration. So if I can begin by maybe sketching out in the form of a structure, the sort of 4 broad areas which I propose to cover over the next 40 minutes or so, and then a very, very much welcome questions from members of the audience participating in the webinar, either in relation to any of these 4 topics or in relation to international arbitration developments in Asia over the past 20-year period in general. So the 4 topics which I propose to cover today are in fact focused on what I would regard as events or matters occurring at the start of the arbitration process rather than in relation to the end of the arbitration process. And the reason why I wanted to start with that is when you are being asked to talk about developments in international arbitration in Asia, more often than not, speakers will touch on issues pertaining to developments at the tail end of the arbitration process. So recognition and enforcement of arbitration awards, the bases upon which you can challenge or set aside arbitration awards, because simply put, these are amongst the more exciting topics that you do encounter from time to time when you're dealing with international arbitration. But just as important and easily overlooked are the developments that occur at the start of the arbitration process. Because obviously, unless and until you can get your arbitration off the ground and grapple with some of the complexities, both procedural and substantive, in the course of the international arbitration process, you don't get to the end game, which is the arbitration award and the bases upon which you might be applying to set aside or otherwise recognizing and enforcing an arbitration award. So the 4 topics which I have specially curated for my presentation this evening are, firstly, to discuss some of the more recent authorities in a number of common law jurisdictions in Asia and beyond, containing or pertaining to the interconnection between arbitration on the one hand and insolvency on the other. Secondly, I'd like to touch on the question of virtual hearings and what's changed, what's new, what are things to look out for, and it is obviously something that we will be encountering on an increased basis going forward, particularly given the current public health situation. The third topic which I propose to address is a development that has been brewing for some time to come. It certainly has been a feature of international arbitration in general, including international arbitration in Asia, and over the past few years has really taken flight and become even more prominent in the work that we all do as international arbitration practitioners or as end users of international arbitration, and that's third-party funding in arbitration. And then finally, I want to talk about interim measures, which is a often used, invoked, and at times can be a potent and powerful tool, either in support of or to frustrate arbitration, and therefore worthy of consideration in the context of any tactical plans which are developed at the onset of an arbitration. So dealing with the first of those 4 topics, which is the interaction between arbitration on the one hand and insolvency on the other. There have been a number of decisions over the past few years, particularly in Singapore and Hong Kong, in relation to the interconnection between arbitration and insolvency. What do you do when a winding up petition, for instance, is presented in the national courts, petitioning to wind up a company on the basis of a debt in respect of which the underlying contract contains an arbitration clause? What is the appropriate standard of review that is applied by the courts faced with the presentation of a winding up petition in these circumstances? Does it stay or dismiss the winding up petition because there is an arbitration agreement present in the underlying contract? And if so, what is the appropriate standard to be applied? Now, the English Court of Appeal grappled with this question a few years ago, and this has provided the starting point for an analysis by both the Hong Kong and Singapore courts. And this is the 2015 decision of Salford Estates No. 2 Limited and Automat Limited No. 2. And the citation is 2015 Chancery 589, where the leading judgment was delivered by the Chancellor of the High Court, Sir Terence Atherton. And what the English Court of Appeal held in Salford No. 2 was, in essence, where there is an arbitration clause or an arbitration agreement contained in the underlying contract, then in those circumstances, what a court should do where it was faced with a winding up petition in circumstances where the underlying contract contained an arbitration agreement was to either stay or dismiss the winding up petition if and to the extent it can be established that firstly, there was an arbitration agreement, and secondly, the arbitration agreement was of sufficient scope to cover the subject matter of the dispute which has given rise to the winding up petition. So that was what the English Court of Appeal held in Salford Estates No. 2. Now, then fast forward 3 years thereafter, where that very issue came up before the Hong Kong Court of First Instance in a case called Re Southwest Pacific Bauxite, Hong Kong Limited, or otherwise known as LASMOS Limited. And the citation for that is 2018 to HKLRD 449, where, again, the same issue came up in that case. And what Mr. Justice Harris in the Hong Kong High Court said was, in adopting the principles which have been adumbrated by the English Court of Appeal in Salford Estates No. 2, Mr. Justice Harris held that similar considerations should be applied to Hong Kong, whereby, notwithstanding that in Salford Estates No. 2, what the English Court of Appeal there was doing was it was grappling with the interaction between the insolvency regime on the one hand and the principles underpinning the English 1996 Arbitration Act on the other. Mr. Justice Harris held that in Hong Kong, similar considerations applied to the interrelationship or the interconnection between the insolvency regime in Hong Kong on the one hand and the arbitration ordinance in Hong Kong on the other. And therefore, all that, it is said, that the debtor, the respondent debtor, needs to do in order to persuade the court to stay or dismiss the winding up petition is to establish to a prima facie standard. A prima facie standard that there was a dispute in respect of the debt, which by virtue of the presence of the arbitration clause is to be referred to and to be resolved by an arbitral tribunal. So both in Salford Estates No. 2, as well as in LASMOS Limited, the English Court of Appeal and the Hong Kong High Court held that so long as it can be shown to a prima facie standard that the debt that has given rise to the winding up petition is the subject of an arbitration clause, then the winding up petition will either be stayed or dismissed in those circumstances. So far, so good. Well, apart from the fact that what you had in LASMOS was you had this sort of tripartite test. And what the court held in LASMOS is that there are three things which need to be satisfied in order to persuade a court to dismiss a winding up application. First, it's got to be shown that the debtor disputes the debt that is being relied on by the creditor in order to present the winding up application. Secondly, it has to be established that the contract under which the debt is alleged to arise contains an arbitration clause. And thirdly, and this is important for reasons which I will explain later, the debtor takes steps to commence arbitration proceedings and files an affirmation, in other words, a witness statement or an affidavit, demonstrating this. And this was the third limb of the tripartite LASMOS test, which was set out in paragraph 31 of the judgment of Mr. Justice Harris in LASMOS. So as long as all three of the tripartite limbs in LASMOS have been satisfied, then so the court held in LASMOS, a winding up application will be dismissed. However, what then happened the following year, so this is 2019, so this is last year, is the Hong Kong Court of Appeal, so the appellate court, held in a case called But Kar Chon and Interactive Brokers LLC, where, well, there were two things which the Hong Kong Court of Appeal held in But Kar Chon. The first was that the Hong Kong Court of Appeal held that applying the tripartite tests which had been set out by Mr. Justice Harris in LASMOS, the third of those limbs, in other words, the limb that requires the debtor to take the steps required to commence an arbitration and filing an affirmation demonstrating this, was not satisfied, and therefore in those circumstances, the winding application would not be dismissed, despite the presence of an arbitration clause. However, what the Court of Appeal in Hong Kong went on to hold, albeit obiter, was they very much doubted that the appropriate standard in any event where a court was faced with a winding up application in circumstances where the underlying debt contained an arbitration clause was the prima facie standard. Rather, the Hong Kong Court of Appeal held obiter was that where there was a winding up application, in order to persuade the court to dismiss that winding up application, the debtor had to establish to a triable issue standard that there was a substantial and bona fide dispute about the underlying debt itself. And so there is a difference, therefore, in these two standards. You have in Salford Estates number 2, which was then adopted by the Hong Kong Court of First Instance in Lesmos Limited, where there was a prima facie standard, so a much lower standard of review. And on the other hand, you have in But Kar Chon, the obiter remarks of the Hong Kong Court of Appeal, where they held that the prima facie standard is not standard, which the courts should apply when deciding whether or not to dismiss a winding up application on the grounds that the underlying debt contains an arbitration clause, but rather the standard that should be applied is the triable issue standard, which necessarily involves examination of the underlying merits of the dispute giving rise to the alleged debt itself. So you have here differences in standards. And what the Hong Kong Court of Appeal held, again, all obiter in But Kar Chon, which was endorsed by a deputy high court judge in the Hong Kong Court of First Instance in a very recent decision called Dayang and Asia Master Logistics Limited. So this is a decision of this year in 2020, was that the reason why there is a difference in the application of these standards is because the public policy considerations underpinning the insolvency regime is not one which is narrowly confined to protecting the interests of the creditor and debtor, between whom a dispute has arisen, giving rise to the debt and thus to the winding up application, but because the policy underpinning the insolvency regime applies or impacts on the body of creditors to the company or to the debtor that is being sought to be wound up as a whole. And therefore there is a tension on the one hand between the insolvency regime or insolvency legislation in most jurisdictions on the one hand and arbitration legislation on the other. This was a theme that was also adverted to in an earlier decision of the Singapore Court of Appeal called Larsen Oil and Petroprom. So here you have, therefore, this schism or this divergence between, on the one hand, the Salford Estates number 2 and Lesmos Limited approaches. And on the other, you have the obiter remarks of the Hong Kong Court of Appeal in But Kar Chon, which was then applied by a deputy high court judge in the Hong Kong Court of First Instance in a case called Asia Master Logistics. What then comes of this debate or the divergence in approaches? Well, that debate or that conundrum was very recently resolved, in fact, on the 7th of April, 2020, so very recently, by the Singapore Court of Appeal in a case called An Group Singapore Private Limited and VTB Bank, where what the Singapore Court of Appeal did in those circumstances was to consider the decisions in Salford Estates number 2, some of the other English decisions which followed Salford Estates, Lasmos, the obiter remarks of the Hong Kong Court of Appeal in But Kar Chon, the decision of the Deputy High Court Judge in Asia Master Logistics, and also the Singapore Court of Appeal looked at the jurisprudence in some other jurisdictions, including in the Eastern Caribbean Court of Appeal in a case called Chin Peng, and also the decision of the High Court of Malaya in Malaysia in a case called Awangsa Bina Sendirian Berhad and Maryland Avenue, and drawing the decisions made in all of those cases in which somewhat different approaches were adopted in all those cases, came up with this decision. The conclusion that had been reached by the Singapore Court of Appeal in the An decision, which in my view is correct and commends itself to not just in Singapore, but also in a variety of other common law jurisdictions, whether in Asia or beyond, is that when you are dealing with this tension between insolvency and arbitration, the standard to be applied by a court faced with a winding up petition by the creditor and an application for a dismissal or a stay of the winding up petition by a debtor on the basis that the debt giving rise to the winding up application contains an arbitration clause is the prima facie standard. The prima facie standard, which is what was set out by the English Court of Appeal in Salford Estates No. 2. And the Singapore Court of Appeal in An Group justified its decision on this basis. Well, there are sort of two very broad overarching justifications for its decision. And just bear in mind that this was a decision by a 5-member of the Singapore Court of Appeal, which ordinarily usually sits in banks of 3. And the judgment of the court was delivered by Judge of Appeal Stephen Chong, who is a distinguished jurist in the field of arbitration. And in a very powerfully reasoned judgment, the Court of Appeal per Stephen Chong JA held that firstly, there is no inconsistency or no tension between insolvency and arbitration. And the reason why there is no tension is because the question as to whether or not there is even a debt which engages the insolvency legislation is one which the parties have, by virtue of agreeing an arbitration clause, agreed is to be resolved by way of arbitration. In other words, the question as to whether or not there is a debt which, if established, would trigger the operation of insolvency legislation, whether in Singapore or elsewhere, whichever jurisdiction we are dealing with, is a matter which, as an anterior issue, the parties have agreed is to be resolved by way of arbitration. So there is no conflict between the insolvency legislation on the one hand and arbitration legislation on the other. And that's a very powerful reason for deciding in favor of the prima facie standard. But the Court of Appeal didn't stop there. The second overarching reason, which the Singapore Court of Appeal relied on in support of its decision in An Group, was to say that the reason why it adopted the prima facie standard of review instead of the more detailed, more granular approach of adopting a triable issue standard of review is simply because this would bring this part of the law in coherence with applications for stay of court proceedings in favor of arbitration in general. Thus, quite apart from the fact where you're not dealing with a winding up application and you have court proceedings which have been brought by one party in breach of an arbitration agreement, whether it's in Singapore or in many other jurisdictions, common law or otherwise, is that the standard of review which a court would apply when deciding whether or not to stay the court proceedings in favor of arbitration is a prima facie standard. So what the court would do is first it would establish whether there is an arbitration clause, and if so, whether or not the arbitration clause is of sufficient breadth to cover the dispute which forms the subject matter of the court proceedings which have been brought. So that's to be decided on a prima facie standard. The Court of Appeal reasoned was that it would not make sense if you have the same debt which has an underlying arbitration clause, and the measure which the national court would then decide, would then apply in deciding whether or not to dismiss or to stay court proceedings would differ depending on whether or not those court proceedings which are brought assume the form of a winding up claim or winding up application or not. So if it was a non-winding up application, in other words, ordinary court proceedings brought either by way of originating summons or by way of a writ action, the standard that a court would apply in deciding whether or not to dismiss or to stay those court proceedings where there is an arbitration clause present would be prima facie standard. It would make no sense. So the Singapore Court of Appeal reasons that the standard of review would somehow be different just because the plaintiff or the claimant decided that rather than start a writ action, it would instead bring an application to wind up the debt company. The Singapore Court of Appeal didn't say either. It went further and said that there is another reason why this is undoubtedly right. apart from bringing the law in coherence with the position in respect of stay applications generally where there is an arbitration clause in the underlying contract. And that is to say, is to prevent an abuse of the court's process, particularly with regards to winding up proceedings. It goes without saying that the presentation of a winding up application and or the advertisement of a winding up application itself has got serious consequences for the debtor company. And it may well be as well that it would cause pressure to be brought on bear on the debtor, who would then have to react to the presentation of a winding up petition in a very short period of time, such that any application to restrain presentation and or advertisement of the petition has to be brought within a very short time frame, and it could genuinely be used as a means of bringing undue pressure onto a debtor in circumstances where the parties had agreed that any dispute about the underlying debt itself as to whether or not there was in fact debt, and if so, how much, is something which will be resolved by way of arbitration. And thus, what the decision in an group does is it upholds party autonomy in circumstances where the parties have agreed between themselves to refer any disputes in respect of the contract which could give rise to an underlying debt to arbitration. Then it is the parties should be held to their contractual bargain, and that it is not inconsistent with the public policy of the insolvency legislation in general in Singapore, or even if this was being considered in other jurisdictions, and those other jurisdictions, to say that that should be allowed to be resolved by way of arbitration before a winding up application is presented in court. So that is dealing with the position in An. And I picked that because this is clearly an area which has vexed many an arbitration and insolvency practitioner in recent years. It's generated no fewer than 6 different decisions in courts of differing levels in Singapore as well as Hong Kong, and it all stems from the 2015 decision of the English Court of Appeal in Salford Estates number 2. And it may well be that that is something which, as arbitration and or insolvency practitioners, to the extent that you will have to grapple with when you are faced with a claim at the very outset, or perhaps you are bringing a claim and you are trying to work out whether or not to start an arbitration claim or to wind up a company. And what do you do if you're on the other side and you are faced with a winding up application in circumstances where there is an arbitration clause in respect of that underlying debt? Now, say, because I sort of laid a marker down when I talked about, if you recall, the tripartite limb of the test which has been laid down in Lasmos Limited, the third of which, you may recall, Mr. Justice Harris said that in order to persuade a court to dismiss a winding up application, because there is an arbitration clause, it has to be demonstrated by the debtor by way of an affirmation. He has an intention, there has taken steps, so it's taken the required steps, I beg your pardon, to commence arbitration proceedings in accordance with the arbitration clause. Now, that element is missing from the rubric of the Singapore Court of Appeals decision in An Group. And whilst this is not something that has been grappled with by the courts in any of the decisions which I've just mentioned in the context of the topic, it would appear that what the third limb of the tripartite test in Lasmos might be said to be somewhat inconsistent with the approach which was adopted by the UK Supreme Court in AES Ust-Kamenogosk and hydro plants, which in dealing with the question as to whether or not the English courts have the power under Section 37 of the English Senior Courts Act 1981 to issue an anti-suit injunction in support of arbitration proceedings, held that they have the power to do so even if the arbitration proceedings itself had not been commenced. So that was the critical issue, or one of the critical issues which the UK Supreme Court was confronted with in AES Ust-Kamenogosk. And albeit that the context was very different, there is something to be said, again, in the name of coherence of the law, that it doesn't really matter that the debtor has not in fact begun or taken the required steps to commence arbitration proceedings, albeit that one can well imagine that if after a period of time has elapsed, the debtor, there is in fact no arbitration proceedings, then perhaps in those circumstances, the court might, if it is engaged with the dispute again, might say that in those circumstances, the winding up proceedings should be allowed to continue because applying the prima facie standard that there is no dispute about the underlying debt, a period of time having elapsed and no arbitration proceedings having been commenced or pursued. So that's just something to point out by way of a footnote in terms of that third limb of the test which had been laid down by Mr. Justice Harris in Lasmos Limited. Now, that's the first topic I wanted to touch on, and I've spent quite a bit of time on that first topic because of the volume of case law that it has generated, and it's genuinely one of the hot topics in international arbitration today. And notwithstanding the English origins of the discussion of the jurisprudence on this, which is Salford Estates number 2, I consider this to be a recent and very significant development in the context of international arbitration in Asia, because these sort of issues arise in the context of disputes in Asia as much as they do in other jurisdictions, but more particularly because some of the more cutting-edge decisions on this topic have over the past 2 years, so we're dealing in 2019 and 2020, there are 6 decisions in total. All of them have come from courts in Asia, particularly the Hong Kong and Singapore courts. Moving on then to the second topic, which is on virtual hearings. And again, I go to the Hong Kong Court of First Instance. This time, I go to a very recent decision. So at the very start of the COVID-19 pandemic, and it's a decision of Mr. Justice Russell Coleman, in a case called Cyberworks Audio Video Technology Limited and Remedy Asia Limited. So the Cyberworks decision, the judgment or the ruling was handed down with reasons on the 28th of February 2020. So again, very, very early on this year, and you might recognize the significance of the date because it was around the time when a number of jurisdictions entered into lockdown, including Hong Kong. And so one of the questions or one of the issues that the court had to grapple with in Cyberworks was whether or not the procedural rules, the rules of the High Court in Hong Kong, allowed for telephone hearings. And albeit that it dealt there in the context of telephone hearings, in my view, the observations made by Mr. Justice Coleman in Cyberworks apply with just as much force to video hearings or virtual hearings, of which no doubt many of you are either familiar or will become increasingly familiar in the months to come. And the issue in that case was the circumstances in which a virtual hearing, or in that case, to be precise, a telephone hearing, would be appropriate. And albeit that the parties had between themselves agreed that a telephone hearing should visit of sufficient a reasoned ruling as to why, in his lordship's view, telephone hearings, and therefore by extension, virtual or video hearings would also comport with the rules of High Court in Hong Kong. And what is particularly interesting is an observation which Mr. Justice Coleman made in paragraph 26 of his decision in Cyberworks, where he adverted to Practice Direction 23A of the English Civil Procedure Rules, the English CPR, at paragraph 6 to 7, which deals with telephone hearings and video conferencing, and made the observation that, interestingly, at paragraph 6.9 of Practice Direction 23A of the English CPR, it provides that no party or representative of a party to an application being heard by telephone may attend the judge in person while the application is being heard, unless every other party to the application has agreed that he may do so. And then his lordship went on to hold, and I quote, this comes from paragraph 26 of his judgment in CyberWorks, this seems to me to be a point of fairness and the maintenance of both the appearance and fact of fairness, which can usefully be borne in mind also in Hong Kong, unquote. Now, Mr. Justice Coleman was dealing there with the situation where, pertaining to a telephone hearing, but as I made the observation before, in my view, it applies with just as much force, if not even more so, to virtual hearings or video hearings. Thus, applying the authority in CyberWorks, and I've looked in another common law jurisdiction. I think there's only one other decision, which is a very, very recent decision of the English High Court, which doesn't really grapple with this issue squarely, but there are signs or indications that perhaps a slightly different view was being taken there. But certainly this issue was dealt with squarely in CyberWorks, whereby what Mr. Justice Coleman had said was that it's not just a point of fairness, but the maintenance of both the appearance and fact of fairness, that you can't have a telephone, or as I say, can be extended to a virtual hearing, whereby one party participates remotely and the other party attends the judge in person. And this applies in as much to arbitrations as they do to court hearings. Thus, in my view, it would be inappropriate, not just as a matter of fairness, but maintenance of the appearance of fairness for an arbitration or a virtual hearing whereby you have counsel for one of the parties attending remotely, and the other counsel for the other party perhaps attending on the arbitrators in person because they happen to live in the same city, and perhaps because social distancing measures have been relaxed, or rather lockdown measures have been relaxed in the city in which the other counsel and the arbitrators are resident or at least present, and thus that the counsel for that opposing party is able to attend in person. And in fact, a few days ago, I was sent a circular by my colleagues at Essex Court Chambers, arising out of discussions which they have had with judges of the commercial court here in England, or amongst others, virtual hearing. And the observation was made that it would be not satisfactory in circumstances whereby you have a virtual or a remote hearing wherein counsel for one of the parties attended remotely and counsel for the other parties did not. Now, that's not a judgment, but it was just an observation that was made in general. But it is, in my view, something that resonates obviously with what Mr. Justice Coleman himself had observed in the Hong Kong Court of First Instance, drawing from what was set out in paragraph 6.9 of Practice Direction 23A of the English Civil Procedure Rules. So that's the second topic I wanted to cover today in respect of international arbitration developments in Asia. The third topic I wanted to cover is in relation to something which has been brewing, and it's a game changer. Let's not mince words here. It is a game changer, not just in respects of those of us who practice in the field of international arbitration, but also a game changer for end users of international arbitration, and that relates to third-party funding. And what we have seen is legislation that has been introduced in, amongst others, Singapore and Hong Kong, expressly allowing third-party funding. We have seen revisions being made, for instance, to the SIAC rules, to the Singapore International Arbitration Center rules, to the rules of arbitration of the Hong Kong International Arbitration Center, HKIAC, allowing third-party funding in arbitrations which are governed by those sets of rules. What is interesting is that there has been a very recent decision. Well, I say very recent, but this time it's 2016. So we're going back slightly back in time over our 20-year period, but still keeping it relatively fresh. And it's a decision of the English Commercial Court this time round by His Honour Judge Waxman QC, as he then was, sitting in the Commercial Court, where faced with a challenge to an arbitration award brought under Section 68(2)(b) of the English 1996 Arbitration Act, which deals with serious irregularity, wherein The sole arbitrator in that case, who was a retired English Court of Appeal judge, had awarded third-party funding costs in favor of the claimant. So just to put it in context, what had happened in that case was you had an arbitration that was governed by the rules of the International Chamber of Commerce, the ICC rules, which the claimant had won, third-party funded claimant, and the successful claimant then sought recovery of his third-party funding costs from the respondent. So this is the sum which the claimant agrees to part company with and pay over to the funder in the event of success in the arbitration, sometimes called a participation fee, it's sometimes called other different things, but it's effectively what the claimant agrees to pay over, part company from the fruits of its success to the funder in the event that he is or she is successful in the arbitration. So the question was whether or not the claimant could seek a recovery of the third-party funding costs, in other words, the participation fee, from the unsuccessful respondent, and if so, whether or not that could cover also after the event ATE, insurance premium. The arbitrator answered the question in the affirmative, said yes, claimant can recover pursuant to the wording of Article 31(1) of the ICC rules, which gives very broad powers to the arbitrator to grant recovery of legal or other costs. And it was held that other costs was of sufficiently broad import to cover third-party funding costs. And Judge Waxman QC, as he then was, held that there was no serious irregularity in respect of the arbitrator's decision in that regard. And of course, given that this was a challenge to the award on the grounds of serious irregularity, was not really the role of the commercial court in those circumstances to investigate as to whether or not, as a matter of substance, the arbitrator was correct to hold the way he did. The question was whether or not he had committed serious irregularity in deciding that pursuant to Article 31(1) of the ICC rules, other costs were sufficiently broad to cover third-party funding costs, and it was held there was no serious irregularity. However, the judge went on to hold, albeit obiter, strictly speaking, that in his lordship's view, the word other costs in Article 31(1), which is similar to the formulation which is used in Section 59 of the English Arbitration Act 1996, was of sufficiently broad import to cover third-party funding costs. And therefore, the decision of the arbitrator in that case was without rights, albeit it goes without saying that whether or not this is the position in respect of all cases would turn on the precise wording of not just the applicable rules of arbitration pursuant to which the arbitration is conducted, but also obviously the specific rules on recovery of costs in the applicable national arbitration legislation. There is also quite a separate question as to whether, additionally to that, it would need to be shown that there were unique circumstances which allowed recovery of third-party funding costs, or whether or not there could be, in general, recovery of third-party funding costs, irrespective of the circumstances. But that is a really interesting development, because the fact you have jurisdictions like Singapore and Hong Kong, and accompanying arbitration institutions in those jurisdictions like the SIAC and HKIAC, introduce legislation changes to the institutional rules in order to allow third-party funding costs, is a game changer in promoting the use of international arbitration. But on top of that, where you have positions like SR and Norscot, which, if it is of broader application, would simply serve to even develop that even further, because then claimants could, if the circumstances are right, and depending on what precise language used in the arbitration institution rules say, and also in the applicable national arbitration legislation, be entitled to recover those third-party funding costs, thus making the prospect of third-party funding even more desirable, which in turn will translate in general terms to an increase or an uptick, not just in the number of arbitration references which are commenced, but also the duration of those arbitration proceedings. So if a party is otherwise without sufficient financial resources to continue an arbitration proceedings with natural, and because of financial means, this would danger. Now, very quickly on the fourth topic, before we move on to questions and answers, is I just wanted to mention very briefly a new development which occurred on the 1st of October 2019. So I'm going back again further in time in reverse chronological order, but not too far back in time. So only to the tail end of last year, whereby there was an arrangement concerning the mutual assistance in court-ordered interim measures in aid of arbitral proceedings by the courts of mainland China and Hong Kong, which was introduced. In a nutshell, what this arrangement does is that it allows or entitles PRC courts, Chinese courts, to issue interim measures in support of arbitration proceedings which are seated in Hong Kong, but only in circumstances where the arbitration is administered by one of 6 institutions which have been named in that arrangement. So these are arbitrations which are conducted pursuant to the rules of either HKIAC or CTAC, the China International Economic and Trade Arbitration Commission, in particular its Hong Kong Arbitration Center, ICC Asia, the Hong Kong Maritime Arbitration Group, the South China International Arbitration Center in Hong Kong, and the EBRAM, International Online Dispute Resolution Center. And what you are entitled to do if you are applying for interim measures from the PRC courts in support of Hong Kong seated arbitrations conducted pursuant to one of these, the rules of one of these 6 institutions, is 3 types of interim measures. There is firstly what is called an asset preservation order, where you can attach assets in order to prevent a respondent from dissipating assets to frustrate the enforcement of an arbitration award. So a bit like a freezing injunction or a Mareva injunction. The second is an evidence preservation order, where the aim of which is to preserve evidence which is the subject of the arbitration proceedings, which might otherwise be at risk of being destroyed or lost. And the third is what is described in terms as a conduct preservation order. And what it really means, conduct preservation order, is that it is simply an injunction in all but name, where it is designed, for instance, to prevent, to injunct the respondent from doing something, or to compel an injunction to do something. So it's either a prohibitory or a mandatory injunction of the kind which many of us are undoubtedly familiar with. So there are tactical considerations as to whether or not to launch those interim measures, and of course, different considerations apply to whether or not this is a positive development or a negative development, depending on whether you are acting for a PRC party or for the non-PRC party. But say, hypothetically, if you were acting for and representing an Indian party, and certainly if you are considering whether or not to insert, and if so, which seat to choose, it may well be in the interest of an Indian party to opt for Hong Kong for one of these 6 institutions where the contractual counterparty is PRC party, because what this would allow you to, if hopefully in the unlikely event that you do go to arbitration, you have the option of applying to the mainland courts, the PRC courts, for interim measures in support of your Hong Kong seated arbitration proceedings, including either attaching assets, attaching or freezing assets, preserving evidence, and also injuncting, whether by way of a prohibitory or mandatory injunction. Or other topics.
Thank you, Mr. Jern-Fei. Thank you very much for that insightful perspectives that you've given. As you pointed out, that the topics that you've pointed out, all the 4 topics that we have dealt with today, are issues that lead to several conundrums that have been there over the last few years. And as you pointed out, the issue with regard to insolvency versus arbitration, because as you might know that India has a new insolvency law since 2016 called the Insolvency Bankruptcy Code. So there are several matters where we have had entanglements, whether arbitration should prevail or an insolvency should prevail. And the Supreme Court has clarified on the same ground as the Singapore Court of Appeal has said, that dispute is the yardstick. So before we move on to questions with Jern-Fei, can I just ask you one personal question that I feel is very relevant? And in fact, there are a few honorable judges of the Madras High Court who are also participating in the webinar. And one respected judge yesterday in a webinar in which he addressed has pointed out the procedural alterations that need to be carried out to our existing legal framework for making virtual courts and video courts and telephone courts, as you said, to be more successful or more practicable. Do you think these virtual courts can be a supplement, or can it even be a supplant to the entire court system, the arbitration system? Do you think it's going to be a supplement with a supplant fight, or what's your opinion on that?
I think the answer is, in a nutshell, supplement rather than replacement. And the reason why I say supplement is because there are different views, obviously, in if you ask, different, whether it's judges or arbitrators or counsel or end users. There are some, even amongst judges, there are some in England who would say, well, the virtual hearing is not appropriate where you have issues of considerable complexity, or there is going to be extensive cross-examination, and where issues of credit are particularly important, where allegations of dishonesty are being made. There are equally on the other side of the divide, there are those judges, arbitrators, and counsel, and I count myself as amongst of those on the other side of the debate, who say that it is possible to conduct virtual hearings in circumstances even where there are complex issues, a variety of witnesses, and even where issues of credibility or allegations of dishonesty are made. By way of illustration, about a fortnight ago, I completed a 2-week virtual arbitration hearing, whereby there was cross-examination of up to 11 factual and expert witnesses. So there was obviously some complexity in terms of the technological arrangements, but everything went well, apart from maybe sort of 2 or 3, which is quite minor in numbers compared, in the context of a 10-day hearing, where we had sort of technological difficulties. And of those 2 or 3, there was only one where I was briefly disconnected from the virtual hearing platform, in the sense that I could see what was going on, but I couldn't hear them, but I could still, and they couldn't see or hear me, everybody else, but I could see from the real-time transcription what was being said in the context of the hearing. So I don't think it is, therefore I think it is a supplement, but to the extent it can be used as a supplement, I do think that it is very effective supplement in that regard, although there is still something to be said about in-person hearings if it is feasible and appropriate. So what I mean by that is, for example, if all of those who are participating either in a jurisdiction, come from the one jurisdiction, or perhaps from 2 or more jurisdictions where strict lockdown measures have been eased or are non-existent, then there may be something to be said about an in-person hearing, especially if participants don't have to travel far distances, even more so when everyone is located in the same jurisdiction. But if that was not the case, then I do think that there is much to be said about virtual hearings being used in place of in-person hearings where an in-person hearing would otherwise not be possible.
Thank you. Mr. Jern-Fei, there is a question, of course, it's slightly touching more on the insolvency aspect than the arbitration aspect. There's a question from Mahalakshmi Pawar, where she questions that under the double taxation avoidance agreement between India and Singapore, how would the creditors or debtors would apply to recovery or can claim under insolvency? I think her main question, I think, is coming back to the very same focus that you pointed out with regard to arbitration versus insolvency. Can I safely assume that the universal test, of course, what has been laid down by the Singapore Court of Appeal most recently, the last couple of weeks back, is that if there is an element of dispute that is there, then naturally arbitration is the preferred forum and it can supersede insolvency. And in the event there is no dispute and it's a clear-cut case, the insolvency courts can interfere and arbitration has to give way. Can I assume that?
Well, I think put it this way, I'm looking at the question in the Zoom group chat, and the question that has been asked is this. It says, Mahalakshmi says, my question is, a creditor who failed to submit proof of claim within the time stipulated, say in the public announcement, may the creditor submit such proof to the interim resolution. And then I'm not sure whether that's the next bit is a continuation of the same question or a different question.
It's a different question. It's a different question. I think the first question she asked is very on the insolvency angle of it.
Yes.
So that's the different part. But I think the second question was regarding the conflict.
Yes. Can I maybe deal with that first question first before we move on to the second question? I think as far as that first question is concerned, I think that perhaps rather assumes against the the precedent that's been established by Salford Estates No. 2 and Lasmos in the Hong Kong Court of First Instance, and also more recently by the An group. And it sounds to me like also the position that's been established by the Indian courts. And the creditor will be allowed to continue those winding up proceedings to the point of submitting a proof of a claim. It's the point that has been held in Salford, Lasmos, and An is that even before you get to the question as to whether or not the creditor has submitted proof of a claim, the question is, are you even in the right forum for that process to take place? And the question that's been asked, and this has been squarely addressed by the Singapore Court of Appeal in An was that, and this is why they said, amongst the reasons they offered for the decision which they reached, was there is no conflict between the insolvency regime on the one hand and the arbitration legislation on the other, because before you even engage with the insolvency regime, and therefore before you get into the question which underpins Mahalakshmi's question to what is the proof of claim in the context of insolvency, there is an anterior question: is which forum proves that there was a debt to begin with? And that is, I think, implicit in Mahalakshmi's question. I think the answer to that is, well, you don't even get into the insolvency legislation for that. So you don't prove your claim or you prove your debt in the context of the winding up application itself. Rather, you say dismiss the winding up application, and proof of the claim or the debt, or describe it as however you like, proof that the money is due and owing by the debtor is to be resolved by way of arbitration. So I think, therefore, the question rather presupposes that that it's really for the national courts faced with the winding up petition or winding up application to consider proof of the debt. I would say, applying the principles in An amongst others, that there's an earlier question, which is, what is the forum to decide the existence, if any, of the debt, and if so, its quantum. And I say that would be arbitration in circumstances of the arbitration clause.
Mr.Jern-Fei, there is one more interesting question. I think it is raised by Mr. Arumugam.
Yes. He's
a practicing lawyer in the Madras High Court. So it's a very interesting question, as you can see. This is what even I wanted to know. Are we moving towards the virtual form? Because, as you know, the demeanor of a witness, the sign language, or the way in which they do it, everything is quite evident in an arbitration or a litigation. As practitioners, we see that day in, day out. He's asking, what if prompting and assisting is taking place in a virtual form, and a witness can remain as cold as what he is still, but still keep getting the assistance and be doing something else? Is that an issue that can be addressed? Tutoring the witness and the witness behavior, can all these be seen in a VC?
Yes, there was a lot of discussion about this topic in particular when lockdown measures were imposed in a number of jurisdictions, and I watched quite a number of webinars organized by different institutions, organizations, law firms, etc., whereby the speakers, many of them adverted to this and say, oh, it's a problem, and maybe the thing that you can introduce in order to resolve this problem is having rotating cameras, or just having a camera that is allowed, that is physically moved if it doesn't rotate around the room, so that people can see at the outset or in the course of a cross-examination who else, if any, is in the room which the witness is physically in. Now, I have to say that my own view is, and at the risk of maybe sounding slightly controversial about this, is that this is a risk that is overstated. And the reason why I say that is because, use our webinar, for instance. Now, this is based on a Zoom platform. A lot of the virtual hearing providers, a number of the virtual hearing providers, such as Epic, EPIQ, use. And the software is not dissimilar with other virtual hearing providers. Now, there are two ways that you can watch this webinar. Same thing happens in the course of a virtual hearing. One option is to have the gallery view, where you see everybody who is dialing in into the either the webinar or the virtual hearing, all sort of in pixel forms in front of your screen. So you see everybody in equal size. The other one obviously is go for the speaker view. If you click on the speaker view option, then by virtue of the fact that I'm speaking now, what you'll see is my face magnified on your screen, and maybe you have a bar on the right-hand side with a few other participants' images, albeit minimized on the right-hand side in the margins. Now, if you've got the speaker view, and you can just try it now as I'm speaking, if you sort of toggle the option, you sort of hover your cursor in the top right-hand corner, you'll find sort of three options. There is a timer, there's a speaker view, or gallery view as the case may be, and there's an exit full screen. Hopefully don't press the exit full screen because we don't have that yet. If you click on the speaker view, then what you see is my face magnified when I'm speaking. In fact, the thing about virtual hearings, or rather cross-examination virtual hearings, is that the reason why I say this is counterintuitive and somewhat controversial, but I do believe in it, is that I do think that cross-examination in virtual hearings is not inferior. It's just a different way of cross-examining. But what you get is an even more detailed, up-close and personal view of the witness, of what the witness is saying, his or her facial reactions, eye contact, whether or not they're looking at you or looking elsewhere, and body reactions, depending on how far away the witness is sitting from the camera. You might be able to capture the upper half of his or her body to questions, which enable you to make just as insightful, not some might say even more insightful observations into things like language. And in terms of coaching, again, because what you get if you opt for the speaker view is corner away from the camera. Instead of looking at you, they're sort of looking at some other place where perhaps someone else is sitting and giving them cue cards or telling them what the answers, or maybe they're looking at humans really shouldn't be looking at and answering questions. So I therefore tell you that the risk of coaching is perhaps slightly over-egged, I say, because it will be easier to detect if the witness is in fact being coached, because you can sort of see them, their eyes roaming around the screen, etc. Also, because it's so up close and personal, where a witness is being coached, there is necessarily a lag between the time the question is asked and the answer is given to allow the coaching to take place. These lags are unnatural. If it happens all too often, people get suspicious. So I think whilst I understand where commentators may be coming from, but those of us who have actually done virtual hearings and you've been through the process of cross-examining many a witness will discover that, in fact, these are not, perhaps the risk of problems arising from this are more theoretical than practical in real terms.
Thank you, Mr.Jern-Fei. Thank you. In fact, it's a very different perspective as you gave. As everyone fears it, but as you point out, maybe in a virtual form, if we are quite aware, we can figure out what's wrong. That's Jern-Fei, there's a very question by where he asks about, I think it would have appeared in your screen, with regard to the increasing tax disputes, where it is going to international arbitration between two nations, yes. Where he says that with taxation being a sovereign function, in many matters, even in India, there was an issue with regard to Nissan, where several crores of Indian rupees, it went to arbitration and ultimately it got sorted out at some point in time. Though providing a platform for ensuring that business grows, do you think cases like this with regard to taxation, the sovereignty and the interest of a country sometimes gets affected? What's your experience on?
Yes, I think there are just sort of unpacking this question is a really interesting, insightful, beautifully complex question. Interesting, but it's got sort of two elements to it, if I can put it like. First is the question of whether or not taxation is the exercise of a sovereign function. Well, of course, it's exercise of sovereign function, but I think embedded in that is the question as to whether or not it should be subject of investment treaty arbitration. And secondly, it is what's my view about the fact that it's being decided by third-party arbitrators. Now, so there are sort of two elements to it, and it's I think one must be careful not, the two are interrelated, but in fact they are separate, deserves of separate consideration. So far as the taxation issue is concerned, well, to my mind, taxation is perhaps a more obvious manifestation of an exercise of the powers of a sovereign state than perhaps other instances might. But in a sense, it's no different from legislation that has been introduced to, say, nationalize an industry, or perhaps legislation that might have a disproportionate impact on investments made by foreign investors. It's just another form of measure that has been introduced by a sovereign state that may or may not have an impact, a discriminatory impact on the investments made by foreign investors. So the question as to whether or not it is of the kind taxation is in and of itself might be said to be susceptible to review by way of investment treaty arbitration. And of course, it's very dangerous to generalize sometimes because I think it all depends on the facts. But so far as one can generalize, I see no reason for drawing a distinction that singles out taxation from other legislation. Interestingly, again, since we're talking about developments in international arbitration, in Asia, again, just focusing on year 2020, because it's such an unusual year. When COVID-19 hit, there were a number of states which introduced measures mitigating against the effects of COVID-19, but some of which obviously had an impact on investment. So for example, restrictions on when businesses could open, and if so, what are the conditions pursuant with which they could operate, whether there were different rules for different sectors of the economy, etc. There were threats by individual investors in order to say that, oh, well, any such measures are obviously going to be either an abrogation of the principle which counsels against, or rather which promotes fair and equal treatment, and so would be susceptible to investment treaty arbitration. Now, to my knowledge, I haven't seen any sort of COVID-19 measures-related cases having yet been brought. There were a number of them which were threatened, but it may be that these are early days yet, and we may yet see investment treaty claims in that regard. The other aspect of the question that's been asked by Rama is, is there a growing concern of such cases, which I assume is not just limited to tax cases, but cases regarding investment treaty in general being decided by third-party arbitrators. My own view is that there is nothing wrong, in fact, much to be said about disputes being decided by third-party arbitrators as opposed to either by municipal courts, national courts, or supranational courts, for the simple reason that obviously, where you stand depends on where you sit. Someone once famously said to me. So if you are sitting in the shoes of the investor, you would obviously regard it as most unsatisfactory for investment disputes to be decided by the municipal courts, by the national courts of the host state. Equally, if you are in the position of the host state, you might take a very different view. But the beauty about investment treaty arbitration, particularly whereby they are decided by what is regarded as third-party arbitrators, is they are decided by completely neutral, independent arbitrators. And of course, if the arbitrators are not independent or impartial, whether in cases where there is evidence of actual bias or perceived bias, then they are obviously susceptible to challenge. There is much to be said about such disputes being decided by third-party arbitrators, as opposed to either municipal courts or indeed supranational courts. Because the problem, I think, with supranational courts is who decides who sits on those supranational courts, and if so, whether or not there may be an inbuilt inclination to find in favor of host state as opposed to investors.
Mr. Jern-Fei, there is one more interesting, I think we'll take two last questions. There is one interesting question from Mr. Arumugam again, where he talks about winding up petition, the case where arbitration is pending and one entity lands up in a winding up under the concerned domestic court. What is going to be the scenario?
Yes. So Mr. Arumugam's question is, if I can just read it out in full, so not least just so that I can sort of get to grips with the question, is after initiation of international arbitration proceeding, one of the parties to such proceedings landed in winding up proceedings lists in the country where such establishment is situated, what would be the legal impact? Well, I think the answer to that question is obviously one assumes that the country or the jurisdiction where the establishment is situated applies principles of common law, similar to those that we have been discussing in the course of this webinar. If that were the case, then in those circumstances where you are that party and you've started an international arbitration, say in state A or in seat A, because that's a seat that you chose. So let's say you are, I won't say an Indian party because I will choose instead a seat of the courts, which we have been discussing today, because then at least I'm on slightly firmer ground. So let's just say Singapore, for instance, if you have a situation whereby or maybe in England, what you have is you have the English courts where the seat of the arbitration is England, say, because that's the neutral territory, and the parties are, say, a Singaporean party and say a Chinese party, for example. And thus the Singapore party has started arbitration proceedings in England, seated in England to dispute the fact that the Singaporean party owes a debt. But in the meantime, what's happened is that you've got a petition or an application to wind up the Singapore party in Singapore, where it is incorporated and where its assets are also located. Now, in those circumstances, then I say, in my view, to Mr. Arumugam's question, this is what I would regard as a fortiori, the position in An-An, because in An-An, if you recall, and indeed, it wasn't just An-An, but it was also a common theme in Lasmos, Batkar Chon, and Asia Master Logistics, where you're dealing with a situation where the arbitration hasn't yet begun. You've got the winding up proceedings. Arbitration hasn't yet begun. Mr. Arumugam's question is on the obverse situation where arbitration proceedings already begun, but then subsequently you are faced with winding up proceedings. Well, in those circumstances, assuming that the court where the winding up proceedings are taking place applies similar common law principles to those we have discussed, then the answer is that those winding up proceedings should definitely be dismissed or stayed in favor of not just anticipated arbitration, but in fact pre-existing actual arbitration proceedings. So this is not just, therefore, you're dealing with an a fortiori position, a fortiori to what happened in An-An. It's also a fortiori, if you recall, to the parallel I drew with anti-suit injunctions in AES Oost Kamanogos and hydro plants in England. So even more so, if you are faced with an actual arbitration, then the winding up proceedings applying the principles in An-An, then those winding up proceedings should obviously be dismissed, or at least in the alternative be stayed.
Thank you very much, Mr. Jern-Fei. One last question from me. I think Mr. Sushil wanted to ask a question, but he's not yet shorted. Yeah, Sushil was the gentleman whom we met in Singapore in our conference. I think he will probably write to you on that. I think the last question from my side would be, Mr. Jern-Fei, is there any conflict you see between the seat versus the venue, the juridical seat versus the venue aspect? Since all of us now are in video conferencing and we are in a respective location. So certainly the venue is changed. Seat, maybe, of course, I think it's a juridical seat. Do you think any complications would arise in the future because of that issue? Because of all of us sitting in different jurisdictions than normally what we would be doing in an international arbitration?
The short answer, Naveen, to the question is no. Because as has been recognized in many an authority in many a jurisdiction, there is a difference conceptually between the seat, which is the legal seat of an arbitration, and the physical place or the venue in which the arbitration takes place. Where sometimes confusion arises is that in some institutional rules, there is a reference to the place of the arbitration. And it might be said that that can give rise to confusion because it's not clear. Because when you say seat, you straight away think of it in conceptual terms to the legal seat. Whereas when you say venue, again, the ordinary meaning of that word connotes the physical venue where the arbitration hearings are taking place. The question is, what does place mean? However, I think the context in which it has been used in those institutional rules which refer to the concept of place is that it's obviously meant as a synonym to legal seat. And the difference, as again in a number of judgments have demonstrated, is that where you're dealing with legal seats, what you're doing is you are designating, you're agreeing between the contracting parties the place or the seat where the arbitration is to be the subject to the courts, right? So the supervisory jurisdiction of the courts of that particular place. So if you're opting for an Indian seat, what you are saying is effectively two things, is that your arbitration is to be the subject of the supervisory jurisdiction of the Indian court, because they are the courts of the seat, of the legal seat of the arbitration. And secondly, what you are agreeing by designating the seat as India, in our example, is that you're agreeing whose rules should apply in the context of any challenge or set aside proceedings. So if you are, I mean, one of the unique features of English arbitration is that under Section 69 of our 1996 Arbitration Act, you have a right to apply for leave to appeal on questions of law, which is a feature which doesn't often appear in the context of those jurisdictions which are model law jurisdictions, where you don't have the option of applying for leave to appeal, although Singapore is obviously considering legislative amendments to change that. And so what you are doing, therefore, is you are, by designating England as your seat, for example, is you are buying into the suite of rights you get in respect of what happens after the award is published, and how it is that you go about either challenging or setting aside, or indeed whether you have got rights of appeal in respect of the arbitration award. So the concept of legal or juridical seat denotes whose courts have supervisory jurisdiction over the arbitration proceedings and whose set of rules are to apply in respect of set aside proceedings which follow on from the publication of an award. And these are to be distinguished from the physical venue of the arbitration, which can take place anywhere in the world and indeed from more than one location, but that does not alter the juridical seat of the arbitration itself.
Thank you very much, Mr. Jern-Fei. Thank you very much. As expected, you were in your best, and you gave us so much of insights, especially in these contemporary times. I'm quite sure that the questions that we discussed today might land up in several courts and arbitral tribunals, and the insights that you've given us certainly give the different perspective to all of us. Thank you very much for that insightful and wonderful session. It's been very nice of you to take time off your busy schedule and speak to us. We'll keep troubling you again for a bigger webinar in the future. Thank you very much.
Thank you, Naveen. Thank you, everyone, for welcoming me. It is very good to have the opportunity of addressing you all. I wish you all the very best. Stay safe and healthy in these challenging times, and keep on arbitrating. Thank you very much. Thank you to the honorable judges and respected guests who have come today. Thank you very much. We'll meet you soon. Thank you. Thank you, Mr. Jern. Thank you very much. Thank you, everyone. Thank you. Bye-bye. Bye.